Hi, my name's Simon-Walland. I'm just going to explain an issue that I am asked quite frequently. I have a court order, it isn't working, or it's very old, it needs to be updated. Can I change my court order? And if I can change my court order, how do I do it? So, first of all, we need to look at what the order is. If it is a order that has come out from a directions hearing, which would be a situation where you have gone to court and for a first hearing, perhaps, and the court have said, right, what we want you to do is go and do X, Y, and Z, and then we'll come back in 2 months' time. Those kinds of orders, no, it isn't worth changing them. You would have had your say at the hearing, and if the court want you to do a drugs test, for example, you would have had your opportunity to say about that test, and the court has still ordered it. If you go to the next hearing and you haven't dealt with it, depending on what it is that is in the order that you've not dealt with, the court may move on or they may do something different. You may want to talk to me to get some advice on that. But effectively, that kind of an order you don't need to change. What you need to look at is a final order. Now, if in your final order you've had a couple of directions hearings, you've then got to your final contested hearing, everything's been argued about, and the court has then made an order. If that is the order that you want to change, then there is a means to do it. Now, this would work on both finances and on children cases. So, first of all, look at what the order is. If it's a final order, then yes, you have an opportunity to change it. The next point you need to look at is when was that order made? You cannot go to court and get an order and then the following week go back and try again to get another order. The court would just look at it and say, well, we decided this a week ago. We're not even going to bother looking again. Similarly, if it was within the last month or so, no, the court are not going to look at it. In order to go back to court and get your order changed, you need a reason. And the reason is likely to have been dealt with, whatever reason it is that you've come up with, is likely to have been dealt with at that last hearing. So you need to have a space of time that is enough for you to be able to argue that the situation is now different. Now, a typical situation is that you have a young child, you go to court, arguing over contact with the child, and an order is made that you can see them for X, Y, and Z time. Now, when that child grows from, say, the age of 2 and becomes 12, that order that suits a 2-year-old is not going to suit a 12-year-old. And then, yes, of course, you go back and you can ask for that to be changed. That if you have a 2-year-old, they then start school when they're 5, maybe, and the arrangements for school will change what that order is. So you just need to have a think about this. Is there something that has changed and therefore makes this order not work? If there is, then yes, you can get it changed. Similarly, with finances, if something dramatic has changed, or you have realized that the other side has not disclosed significant information that would have had a bearing on that order, then yes, you can go back for that as well. Now, was the order by consent or was it ordered by the court? Now, a consent order is one where both parties, even if you're in court and you're arguing about things, you reach an agreement between yourselves. And if you reach agreement between yourselves and you have an order made, it is much, much harder to be able to go back to court and have it changed. Now, the example I gave in the last section, where the child has grown up and therefore it isn't relevant any longer, that's fine on a consent order. But if you have agreed something, it is much harder later on to be able to say, well, yes, I agreed it then, but I don't agree it now. The court won't entertain that at all. But if there is something that has changed, then yes, you can go back and have the order changed. If the order has been made by a judge or a magistrate and it's actually been ordered by the court, then you don't have that issue. We then need to look at what needs changing. Now, the scenario, again, coming back to this situation with a 2-year-old, maybe they're now 7, 10, 12, whatever it may be, the order would need changing. So therefore, that is fine. You can go back and change it. If you're looking at the fundamental basis of that order, yes, of course, you can go back and change it, but you've got a harder battle on your hands, more likely, than if it's a smaller issue. Again, you just need to have a look at it and have a think about it and balance your chances of getting the court to overturn the previous order, or not, in fact, not even overturn the previous order, but to make a change to it, which is what you're looking for. Now, the option that avoids going back to court is to try to reach an agreement. Now, obviously, if your 2-year-old is now going to school and your original order said that you pick them up at 2 o'clock on a Friday, you can't pick them up at 2 o'clock because they're at school and they don't finish until 3 o'clock. Now, it may be that you just pick them up at 3 o'clock because you could argue that from 2 o'clock they were in your possession anyway. But it may well be that you now want to add overnights to that stay, and you need to talk to the other parent to say, can we agree something rather than go back to court again? And you need to ask nicely, you need to be polite about it. Otherwise, you're just going to get into an argument and you both become very rigid in your positions. So if you want some things, some flexibility to be built into that order, you can both agree to change the order. I would say on all court orders, but sometimes these things might be missed, it would say, and such further and other contact as may be agreed. So it does give you the opportunity to make changes. If you are going to make a change, it is important that you get it in writing so that both of you know what you've agreed and what you've changed. Now, having it in writing, it could be a text message, it could be an email, it could be a letter. It doesn't actually matter. As long as you can prove that the other side have said, yes, that's fine, I agree to that change, we will now do the handover at 5 o'clock. You can now have overnight stays for 2 nights every other weekend, or whatever it may be. Yes, you can have a holiday, whatever. As long as you've got it in writing, then you're safe. If you haven't got it in writing, then you're going to need to say, unless you can reply to my text asking for this change, unless you can come back and say, yes, I agree to that change, or yes, I agree to change X, Y, and Z, which would be better because then it's clearer, then you're going to have to go back to court to get the order changed. What you don't want is to find yourself in a position where you have collected a child from school and then the other parent says, well, I didn't agree that at all, and they call the police and everything blows up into a big argument again. You don't want to go back to court if you can avoid it. If you cannot reach an agreement, then you would need to make an application to the court. Probably exactly the same as you did before. Now, on a children application, you would use a C100 form, and you are actually asking the court to vary the existing order. And in that application form, you would just explain that you had an order which was made when the child was 2, they are now 7, the situation has changed, and I would like an order that will reflect their age or reflect the change in circumstances, whatever it may be. And then that will go into the court as a standard application and be dealt with as a normal hearing. If it's a financial order that you're trying to change, then you would use a Form A, the same as you did when you made your original application, and on there you tick the box to say this is to vary an existing order. If you need any advice on this at all, then please contact me and I will do my best to assist you and guide you in the right direction.